All right, we'll get started. Happy New Year to everyone, and welcome to another episode of the Beverly Hills Bar Association Family Law Presents Direct Examination with Dan and Lauren. I'm Lauren Youngman from Youngman Reichstein, and during each episode of our show, we explore our guests' personal and professional history and dig into meaningful legal topics. Dan is out today, so I'm very happy to be joined by Jenna Spatz from the Barnett Law Group. Jen and I were actually co-chairs of the family law section back a number of years ago, so it's nice to be back together. Please continue. Please continue to join us for upcoming episodes. They're always at 12:30 p.m. live on Zoom, and almost always the first Wednesday of the month. Next up is Michael Trope on February 7th, followed by Kimia Klein, Adam Lipsick, Evan Itzkowitz, and more. A housekeeping announcement: you will receive your MCLE certificate shortly after the program. Please take a moment to complete the survey that's included with your certificate. Jenna, would you like to do the sponsor?
So the Beverly Hills Bar Association Family Law section is sponsored by White Zuckerman, Warsofsky, Luna, and Hunt. White Zuckerman, Warsofsky, Luna, and Hunt provides a wide variety of resources to complete almost any litigation project, large or small. They also provide traditional accounting and tax services. We invite you to contact them to discuss your specific accounting needs and to learn more of how they can help you. So thank you to our sponsors.
Thank you, Jenna. All right, so for today's episode, we are thrilled to welcome the supervising judge of our division, Judge Shelley Kaufman, for our first episode of the new year. Judge Kaufman is sitting in Department 2 and has been assigned to family law since joining the bench in 2014. We have, as a start, since apparently some people still are thinking the show is about direct examination instead of a direct examination of our guest, Judge Kaufman has a couple of direct examination tips for us.
All right. Hi, everyone. Happy New Year. Thank you very much for inviting me to start your program. A lawyer ran into me in the hall and said, so I can't wait to hear about how to do a direct examination. And I said, that's not what the program really is. But here's my two tips. One, and they won't come as any surprise. One, and it's not me confer, it's to prepare your client. Clients have never testified in court, or even if they did at an RFO, they didn't at trial. They've never been in trial, perhaps. So they need to understand, they should not be surprised with any questions. And because you prepare them doesn't mean you coach them. It's not the same thing. So you need to talk to them about what you're going to ask them. They shouldn't be surprised. The second tip is, I don't want to call it pet peeve. Your question should be eliciting a fact that's important. So the question that starts out, do you remember what happened on October 1st? Who cares? The question is, what, if anything, happened on October 1st? So go straight to the heart of it. Those are my two tips.
Those are great tips. Thank you for injecting a little actual direct examination into our program. So now for our turn to do a direct exam. We talked about this right before the show started. We've had other sitting judicial officers on in the past, but something we've never really done on the program is go behind the scenes and learn a little bit more about the inner workings of the court. Just as a starting off point, how do judges even get assigned to the family law department in the first place?
In the very first place, when you first become appointed or elected, you meet with the presiding judge and the assistant presiding judge, and they tell you where you're going. In my case, almost 10 years ago to date, I was sworn in on January 17th. You usually meet before your swearing in date, and I met with Judge Wesley and Judge Kuhl, who said I was going to the family law division, and I was pretty excited about that. And then I got a call from Judge Gordon, who invited me to the division, and I was excited from the get-go. So that's if you're a new judge. Then the next thing that happens is we have a retirement and somebody's leaving. So judges, Jessner, our presiding judge, and our assistant presiding judge, Tapia, have started something very new, started something in 2023 that's very new, and personally I think is wonderful, is that an announcement goes out to all of the bench officers. There will be a vacancy in X district in X discipline. Anybody interested, please reply, fill out this survey and submit it. And there's a deadline. And anyone interested says, I'm interested, and this is why I'd like to go to this assignment. Then the presiding judge, the assistant presiding judge, and usually the supervising judge of the division, pursuant to the California Rules of Court 10.603C, does an analysis of who should be chosen. This is a very new process to provide as much transparency as possible and make sure people who never thought they might be interested in a certain assignment might be perked up when they hear about it. So almost all assignments are done that way, except when we're placing new judges. New judges do not participate in that. They get assigned, and sometimes there's bouncing and dominoes that go to get them into the new assignment, and other people get moved, so we don't necessarily publicize those movements. So that's how it works.
And in your opinion, what are the biggest challenges for a judge joining the family law division who comes without any specific family law background?
The biggest challenges, if you've had no family law background, such as myself, you face the first big challenge that everyone faces is being a judge. So the best lawyer in the world has never been a judge. Maybe they, if they did some temporary judging, they volunteered to be a temporary or a TJ, which, yay, promote the program, then it's not such a shock. So anybody who's thinking that they want to be a judge should really sit as a temporary judge, because that in and of itself, the first objection you get and somebody says objection, you're like, who, I have to rule? So you need that rhythm. So that's difficult for everyone. If you've had no family law background, of course, you know, the two family law codes, I remember somebody handed me the code and said, learn it. And I was like, I don't have a photographic memory. There's no way I can learn the code like that. So you have to learn family law, obviously. If you've had a civil background like I did, at least I didn't have to learn the Civil Discovery Act, how the civil code works, how motions work. That wasn't strange or foreign to me. If you haven't had a civil background, I should say civil litigation background, and you had only a criminal background, now you have to learn family and civil. But what you don't have to learn if you were a PD or a DA is how court works, because you know how to do trial. You know how to put on a direct examination, you know how to cross-examine, and you know how to prep a case because you've been watching it and doing it for a long time. So, you know, it's not perfect for anyone without a family law background. But each of those disciplines have their advantages.
And what is the training process when a judge is assigned to family law? It sounds like for you, it was someone handing you the family code, but
no, that was not my training. It was just somebody who said you really need to learn the family code. That was not part of the training. And what I did 10 years ago and what we're doing now is a lot different. I think we have a pretty rigorous program, our court ourselves. I mean, the state itself has primary assignment, which the judges don't go to right away. There's only certain times of the year, but it should be done within the first year. And that's an intense week of the law and family law. Then we have other trainings by the state, which have to do with being a judge. Our court, when somebody starts, it's about a 3-week program. And we introduce them to the court system, meeting certain court personnel, self-help, family court services, kind of the administration aspect, like how does it work? What do you do with the JA? What do you do with the deputy? What is your role? Then we have different people, depending on when somebody starts, working with those people individually. If they've never done family, they've got to learn how to do the disso master. If they've never done family, they need to have training and information on custody. They always meet with Susan Thrall of Family Court Services. And they go around and meet with the different judges and observe home courts, observe restraining courts, because everyone does restraining orders. And that's what they do. And we can't have it so mapped out because you don't know when someone's going to start. So if I start tomorrow and one of the people who's usually the point person for Disso Master is on vacation, or somebody else has to do it, or we wait a week and have that done later. So it's not like day one is this, day two is this, day three is this. And I like new judges to observe many home courts because everybody's got a different style, and you want to pick up, things that you think will work for you. You can't imitate somebody else's style if it's not you, but you do want to see how different people handle their courtrooms. And my personal experience in terms of learning family law, I literally just took each, because I can't read the family code and just absorb it. There are people who can do that. Every RFO, everything that was in front of me, I looked up every single case and every single statute until I remember that I knew what it was. That was the easier way for me, so that I learned as it applied to something, as opposed to just read, I don't know what number, but a number 3011 in the not connected to a case.
Right. So
it took a really long time to prep. I mean, each case I would look up, even though you could tell it was just cited as boilerplate. I thought, well, I better know what the boilerplate is, and then later I won't have to look it up.
And looking at this from the flip side, what, in your opinion, are the best practices for the attorneys themselves to implement when they're appearing in front of a relatively new family law bench officer?
So, I mean, I think my experience with our bench is, and in particular, new judges, they read everything. So provide the appropriate information. The statute, the case that you want to make sure is important to this case. We tend as lawyers to cut and paste a lot. And thank goodness we have computers so we can cut and paste, and we're not, retyping and reinventing the wheel. But each time you do anything, you need to look it over and say, are the things I'm citing applicable to this case? Don't just throw in something from an old case because you don't even remember it and you're not sure if it's important, so you just leave it in there. If you want what's important to be front row and center. If you're seeking a modification of permanent spousal support post-judgment RFO, do you really need to write every single one of the 4320 factors? You don't have to. I mean, we have the code section, we have it. If you use the form, you have nice little paragraphs. Now, it works well if you're going to put the code and then write your explanation. But I do see sometimes where somebody will literally just type 4320 and then go on in 3 other pages to talk about it. But yes, you've got to give the law and you've got to give the statutes and the cases.
But maybe a little bit more concise and targeted.
And targeted to the case at hand.
On the similar topic here, can you talk about how the family law division has grown? I know you just sent out an announcement at the beginning of the year that there have been a lot of changes.
Well, we are 71 bench officers, and for some of you who've been practicing a very long time, I hope, it's always strange to do these programs because we can't see you. But I'm hoping some of you go, what? Wow. 6 of the 71 are commissioners in the AB 1058. So if you just go, where are all the 71 people? If you don't practice in the AB 1058 courts, then that -6. In the last 2 years, we added 3 courtrooms that are designated as restraining order only. Initially, I'm thinking if my numbers are right, for just civil harassment, but we're trying to mesh them together with the all standalone restraining orders. We added 3 new home courts, and that's on top of things that have grown. We added an AV, Torrance, and Mosk. And, it's one of my hopes is that we can continue to grow the division. I mean, I know that our present PJ and APJ and past PJs as well understand the importance of this division and the need for more bench officers. As we get new bench officers and we're relooking at the structure of the court, my hope is that the resources will be identified, that we really need more resources on our side of the table to handle a growing community of needs.
And you mentioned, Judge Kaufman, that you're approaching your 10-year anniversary in the family law department. Congratulations. What is it, do you think, is the main factor that's kept you in family law for so long?
You know, I looked back at, I don't know if any of you know this, but the Daily Journal does a feature. I mean, I know you see the features, but about 1 year into being a judge, they do a feature across the state. And I, of course, kept it because that's a big deal when you first get your feature in the Daily Journal. And I looked at it today just in preparation and thinking about this. And the title that the journalist wrote was Perfect Fit. And I think that my path to get here was, everything I did was my path to get here. I just didn't know it. And I feel like it sounds trite, and it's not meant to be trite, but the kind of practice I had was really, quote, helping people, or at least that's how I viewed it. And I feel like this division, we are serving the public in a time where they need us. I mean, I guess everybody who comes to courts needs the court, but it's such a hard time, and it's not things out of our realm. I would hope to think that most lawyers and judges, crime is out of their realm, even if they've been practicing it. We all have issues with children that have children or have friends who have children. We all have either personally experienced issues in our family with anything that can touch the family law court. So I keep liking it. That's it. So I keep staying.
Well, we definitely don't want to gloss over your path to the bench, and we're going to get to that a little bit later in the program. But do you think that other family law judges that have stuck around, maybe not as long as you, but maybe for more than average, share the same view?
I mean, I think, everybody's different, and everybody, I mean, people who had a family law background, that's sort of their calling, although they too could say, hey, I want to try something new after, 10, 20, 30 years of being a family law practitioner and now a judge. I want to do something new. You have to, and some people love it and want to leave because they just want to try something new, just want to do something different. And you often hear people say, I want to try jury trial. I just want to do some jury trials. I did 40 jury trials as a lawyer in my career, which is kind of a lot as a civil litigator, not if I was a criminal practitioner. And I always said that when I started, I'm going to eventually go to civil because I want to, do some jury trials. And I don't know if I've digressed from your question, but I'm going to tell the story anyway. I was walking down the hall on the 5th floor, which is where I originally was. And I was thinking, I can picture this, and I saw a bunch of potential jurors out in front of my colleagues. And I thought, yeah, I'm probably going to want to do this. And I thought, why do I want to do a jury trial? And I thought, I just want to be the leader of the pack to let people who come for jury service feel really good about the process of our courts. And when I thought that in my head, it's as if somebody threw a brick at me. It was a total epiphany. That moment, I just don't know when it was. And I said, oh my gosh, that's what I do every day in family. Is my goal is that the people who come in front of me, that they leave this court not feeling devastated by the process. So why do I need to do a jury trial? I mean, I'm doing it every day. And that showed me I didn't really need to leave the division, because that was kind of the only thing that I personally was thinking about.
Are there certain steps or programs that the department has in place to encourage retention of the judicial officers in family law?
Steps. I feel like that's been my mission since I've even been ASJ. I mean, I think the hope across the state, if more family law practitioners become judges, more of them will stay. I mean, in certain states, I mean, certain counties, you do everything. But in our county, I think everyone knows there's been a whole push to encourage people with family law experience, dependency experience to apply for the bench so that they will be more interested in longevity, just like all the PDs and the DAs, you know, came to the bench and stayed in criminal. Retention is to make a good division. You know, you're not going to change somebody's opinion. They think they just want to try some other things. You know, they want to try. That's just it. You are going to have bench officers who this area of the law is just too hard for them, whether it's emotionally, I don't want to say intellectually, because I think everybody's capable, emotionally, they just can't. And I get it. I get it. It's hard. But for the people who aren't falling in that category, making it a better assignment with support is hopefully something to keep it. It's a great group of people where, you know, we try to promote the congeniality of our division just to keep people in the family. So just pun intended.
Good one. And in terms of a day in the life of the supervising judge, how much of your day is spent doing logistical operations of the department versus serving on the bench and with cases? How would you describe it?
Well, I'm definitely serving on the bench with cases a whole lot less than I was before I was supervising judge. I don't think I have a percentage. I'm not going to say 50-50, 60-40. Logistics, you've said a great word. I spend an enormous amount of time on logistics. I kind of was doing a lot of logistic work as ASJ as well. And since I like to call it the great shutdown in March of 2020, when we had to shut down the courts and we had to limit services to the public, obviously, you know, it was devastating for your clients, for everyone. It's sort of been my personal mission, along with some others, to not have things continued because, you know, the judge is out sick. In the past, I don't think anybody thought about it. You know, you were sick, you didn't come to work, that happens. You continue the cases. Because so many things have happened, and it could be your case. The judge, it's not just the judge is sick, opposing counsel sick, the party's sick, and we have those things happen. But I feel like if I was a member of the public and knew nothing about it, and you show up in Department X, and you know, and if it was like my cousin Vinny, a sign on the door, courtroom closed, you know, we're out sick. I would look around and go, well, what about all these other, especially at Mosk, what about all these other courtrooms? And so the logistics are trying to get cases elsewhere so things aren't continued. In addition to a million other logistics, but that on a daily routine for the last almost 4 years, sad to say, is constant.
Mm-hmm. So before we move on to our next topic, if just still within the realm of logistics, if you could wave a magic wand and make any change that you wanted, what would it be? And you can say court reporters.
Yeah, I think when you and I had a little chat ahead of time, you said something besides court reporters, which that, you know, that's not fair. That would definitely be a wand. So I'm not gonna. I'll answer your question. I don't want to be a politician, and answer something that you didn't ask me. But it's a wand that we all need to start waving. It is tragic that people come to court and don't have a record of what happened in court. And how that's going to be achieved is going to be all of our efforts. Talking to your legislatures, even grassroots on the court reporting end. I think you know what I mean by talking to your legislator. How can the law change so that if we don't have court reporters, what's our backup? Is it electronic recording? Why not? then there's a grassroots, going to schools, talking about being a court reporter. It's it's not an easy school. It's not an easy job, but sure pays well. And I just think, kids and young people have no clue about it. So the magic wand, other than that, which is a huge one because it's tragic. I don't know if this is a magic wand because I think it's something that I'm trying to work on, and I think is happening, slowly, is continuing to grow the division. I think that we need more courtrooms, more judges, more bench officers. The cases are more complicated, more involved. They're, even in the restraining order world, it isn't like it was once when abuse was physical. Did he or she hit you? Who do I find credible? I find the person who said that he or she was getting hit credible, therefore I grant the restraining order. That's like 10 minutes long. I mean, maybe it's a 30-minute if credibility is really, really, really a question. But now it's a whole world. And that takes up a lot of time. So the magic wand, if it's a wand, would be that. That would be one thing to grow the division. Grow our mediation services through family court services. They're challenged in finding qualified people to fill those spots. I think it's a critical step for litigants to be part of that process and try to resolve their own custody problems rather than have, the person in the black robe decide for them.
And based on where
and
we are,
fix the buildings, and there's a
that's a good one. And based on where we are right now in this post-COVID world, what are your thoughts on virtual appearances for hearings, trials, and the like?
Okay, so obviously it's my direct exam, so you're asking me, not on behalf as the SJ for the division. I'm a huge proponent of remote appearances, and many of my colleagues will, not have the same view. We all know how challenging it can be. We also know when it works, it's wonderful. Just this morning in my courtroom, they couldn't hear me. I could hear them just fine. So I'm writing, it was just a continuance, but I'm like writing signs up about the date. They said, how about this date? And I'm like, no, how about this date? It was on our end. So that's not fun. I'm a huge proponent because I love that none of you, we're happy to have you all come to court. Happy to see you all, always. But I'm happy that if I set a quick continuance on TSC, or you file an ex parte stipulation to continue something and I want to talk to you about it, I don't feel guilty to say, show up remotely at 1:30 tomorrow, because it's not really a big sweat, for you to do that. That being said, there are, there's complications. It depends how organized you are. If you haven't organized your exhibits, and my favorite line, why didn't exchange the exhibit? Because it was for impeachment. Well, now what do you want me to do? The person is remote. How do we get that to them? So I'm a proponent of it. If you've got the ability to do it, why not? But coming to court, is still coming to court, and being there in person and having that whole connection with the court, the judge, the witnesses. I do a lot of Hague cases, and most of the petitioners are in another country and can't come. And that's always the way it used to be, and they had to be on the phone. But now they're literally, it's great. And if it's interpreted, they're talking to the interpreter, but I'm seeing their face. So it's a great system.
I mean, it's definitely practical, that's for sure.
Yeah.
Let's talk about case management a little bit as our next topic. How do you feel that your division is moving cases along? Are there certain bottlenecks, obstacles?
I I think this is a work in progress, and even for me as SJ to start kind of analyzing on a broader scope how cases are moving along. The court has moved to a lot of data study. When I say the court as a whole, family law is complicated in terms of data study because a case filed is different than a civil case filed. I mean, a civil case filed, starts and ends with the verdict and maybe some post-judgment motions. I mean, the family law case starts and ends with, I'm not trying to be funny, but the death of a party for the most part, and even then. So we're trying to develop kind of measurements, how many RFOs before trial, things like that. We're trying to figure out what is the criteria to analyze to see how things are flowing. A timeline just doesn't work. We do have the Elkins requirements, and we follow some certain guidelines. Of course, everything went, kind of haywire in March of 2020, but some people are a little bit better at case management than others, but it's not just the bench officer. It's each case is so unique to itself and has its own, the cases that come to me, and I am sad that they're old. I call them, you're an old case. You aren't old, but you're an old case. There's a whole myriad of reasons for each one of those cases. It's not one reason. It's not, oh, X happened or Y happened. It's this and that and the other thing. Sometimes parties, I'm sure on your end, are just not ready to get there. And, you're fighting to get the stuff you need because they're not ready. When people come in front of me for either a TSC and I'm prepping them for how to be in an MSC or even MSCs, I like to tell the litigants that it's important that they cooperate with you, that they give you what you need, because you're required to turn it over. And if you don't, the whole process just gets bogged down. So I try to help you out to do that, to let them know that when you say, okay, and now I need your bank statements and your credit card statements, and by the way, the receipts for the vet, and it's like, really, he or she knows that, what all that is. So they have to understand, that's part of good client introduction in the beginning. We need to get a lot of stuff before the court and to the other side.
And in your experiences for the cases that make it all the way through trial, what do you feel is the biggest obstacle to settling those cases?
Custody's tough there's no business evaluation. So if a parent in their heart of hearts really believes that the other parent, just can't do the job the way they can, a judge is going to decide. I mean, you can't compromise custody if you have that belief. You can talk about the finances involved, but it's hard to say, okay, this is going to cost you $25,000 to try this case. And it's like their kit. I mean, it's like putting a price. I mean, if there's no money, that's a reality. So personalities, I guess, and beliefs of your clients, not preparing a case enough so that it could be settled, and there you are buttressed against the trial date. So just go forward.
Well, what can attorneys do from your perspective, besides just, prepping clients to know that they've got to turn over a bunch of stuff, but to help drive an early settlement?
Well, I think it, goes to the initial look. I was never a family law practitioner. I was a civil litigator and probably most of my cases were 80% plaintiff and about 20% defendant. And I don't pretend to know intimately what it's like to deal with somebody who's coming in and said, my life just fell apart, my relationship fell apart, and everything's upside down. In my intimate world, not just my work world or some accident that happened to me. But I think the initial client interview, the expectations and the understanding of the process, maybe it's not the initial, maybe you don't want to bombard the person, day one, but soon into the process, it's worth having, this is how it works. And acknowledging, it might be frustrating to have to, go through your bank statements and print them out. It might be frustrating to do this, but, show them the book. I don't mean necessarily the statute. I do that in court sometimes. I'll just go like this. I have to follow this family code. Your lawyer has to follow the family code. And, without being condescending, these are the things we have to do. We don't have a choice. And we're going to either do it sooner or later. The easier we do it, the smoother we do it. It's going to be less expensive for your clients. It's going to be less painful to be through the process, or whatever words you want to use.
And in terms of the working relationship between counsel, how, if any way, have you observed that the relationships between counsel and the collegiality between counsel has impacted the cases? And have you noticed any changes since you've been on the bench?
I started out in the home court, then I went to the trial court, and then I went to the settlement court. Of course, the settlement court is very, very different because, you come there thinking, can we settle? And now I have like a mixed bag of everything. I do think it's improved. I mean, I don't know that I can point to one particular thing, but I think there, I don't know if it was the March 2020, great shutdown that sort of people went, how do we do things differently? The fact that we can be remote and not have to run to court and have that stress of the traffic and parking all the time, and wondering, oh my God, I have to do an appearance in Van Nuys and then I get to get downtown. I mean, that's a very stressful thing in your practice, which doesn't help dealing with an opposing counsel who may just be rude that day. So I do think there's a certain amount of, happily to say, improvement and congeniality. I mean, I know you all hate when we say meet and confer, but I mean, there's certain things that you have to do. Are you going to appear remotely, or you're not going to appear remotely? If you appear remotely, I'll appear remotely. If you want to go in person, I'm going to go in person. And already starts the dialogue that, there's no game playing anymore, or I don't know if there ever was, because there wasn't remote appearance, but there's no game playing about, I'm going to go to court and not tell them, because the court doesn't care. They're not going to say, oh, you're in court, so I like you better. I like your client better. That's just not what's going to happen. I might be able to hear your client better, but if I can't hear the person who's remote, it's just going to take longer. I'm just going to have to, we'll have to figure it out. So I think that you all have, I think you have a more congeniality. And maybe not seeing each other regularly and then getting to see each other again. It's like, I'm so happy to see you, even if we fought, before.
Well, what about when the attorneys just don't get along in those cases where there's a lack of civility, whether it's on, part of both counsel or just one? How can judges intervene, or when is it appropriate for judges to intervene? Should they be calling out bad behavior? Should they be sanctioning parties with litigation tactics when they're brought to their attention?
I mean, as you know, each bench officer is an independent bench officer, will make, his or her own decisions about how to conduct their courtroom. I mean, civility in the courtroom is paramount. It's required. It's part of our canons of ethics. We can't, under the canons, we can't allow people to be discriminated against. We can't, allow that kind of conduct. So we have obligations. We have obligations to keep control of our courtrooms. So yes, the judge, needs to do things in the courtroom. If it's raised outside in pleading and saying, look at these horrible letters I'm getting, which thank goodness, I think in my 10 years, I have not had, I can't even think of a situation where lawyers have ran to me and say, oh, look what I'm getting. I don't think any, nobody's going to curry favor with anyone. I mean, everybody's a professional and needs to, if you feel somebody's acting appropriate, then you need to do what you need to do under the rules of civility for attorneys. What we have to watch out for is what happens in our courtroom. And, you know, maybe more specific, meet and confer orders. It's not just meet and confer. This is what I want you to do. I want you to, you know, I did a lot of practice in federal court, and this is where you'll get, if you're not working it out well with your opposing counsel, then you'll get orders that you have to potentially take each exhibit and state, you know, file a document saying what the objection is and what the basis for the objection is. And, you know, it can be much more convoluted process if you're not discussing discovery appropriately. It may be, well, this is what you're going to do one by one. So somehow you're going to have to do it.
And in terms of the settlement programs that are being offered by the court right now, can you give us a description of the different options that are available to the litigants and which cases are best served by which type of settlement programs?
Okay. I'm gonna answer something that sort of went to another question, which I forgot what it was, but about, you know, what's out there for your clients and, you know, what can we do? As you all know, you've created amazing programs outside of the court. The VAST program, both, you know, through the Beverly Hills Bar and through the Valley Bar. That's something that I don't know how many lawyers really avail themselves of it. And that's outside of the court. We don't order it. Sometimes I'll throw it out to people. The DSO programs across the county, that also answers the question, what can we do to get our clients thinking about settlement? Maybe you're not going to settle the whole case, but if you go to the DSO program with your client, maybe you'll settle the RFO, or they'll get thinking a third party in a quick environment is going to be raising their antennas to the broader scope of the case, which means we need to have DSO officers in all our courts so that we can help. Okay, so that's kind of on your end. And I'm a huge proponent of it. I think that litigants should talk to third parties often. Third parties meaning third party neutrals. That it's rare, boom, we're just going to talk and it's all over. I mean, there's a lot to process. So the more they've had an opportunity to get insight from a third party, whether they settle that day or not, I don't have a statistic. I don't know if we could ever do the statistic, but I would bet their chance of settling is higher than the case that never went in front of a neutral of any kind, be it DSO, be it private mediator, be it mediation, settlement conference to the court. Okay, so what do we have in the court now? We have settlement conferences, mandatory settlement conferences, and settlement conferences. Those are the only two under local rule 5.14. My view is they're basically the same. There's no difference. You need to be prepared. We have several judges doing them. We have to make sure we have enough judges to try cases for cases that need to go to trial, because you can't try people's cases. You can volunteer and be a DSO or a VAST officer and help settle cases. So our first priority is to make sure we try cases. I am a huge believer, especially in the family law arena, that settlement is better for people because they have a hand in their own personal destiny of their children, their assets. I wish we could have every case just have, you know, private sessions, you know, all the time, but we can't. I developed, it just didn't really launch, something called the YES program, which is Your Early Smart Settlement Program. And I'm revising it a little bit because the concept for me is to bring a bunch of people in, maybe 6 or 8 cases at the same time, kind of talk to everybody at the same time, explain what's going to kind of happen in the length of a litigation, understanding what the court does, what they can do, obviously trying to settle the actual case, but not private delving into facts, but walk around and do little caucuses. So the revamp in my head, but I haven't really shared with my bench officers, so if they're on, is one of the criteria was that they had to have certain things done already, such as preliminary declarations of disclosures. And the reason for that was you can't really sign off on a settlement agreement without that. But I thought, you know, if they can come in and they might settle the case, maybe it's not enforceable, but I've got a buy-in that probably it will, because you can tell about the preliminary declarations of disclosure if that's just kind of a side note to the real case. So it's going to be revamped a bit. I want litigants to understand it can be a very convoluted process, and I think a lot of them just don't know that until they're so deep into it they don't even know how to come out of it.
Would that program be for pro per or?
And my other criteria was that you had to have one lawyer so they could write up the agreement. But now that we've brought back in expedited judgment program, and many of you volunteered to do the judgment assistance day program, I think I can do self-represented litigants as part of that as well. Because my thought was, you sign right now, we're going to have an agreement, but I don't think if that happens, great. But that the focus more is maybe you're not going to settle today, but you're probably going to settle in the next 30 days. And finalize it, I should say.
Is the protocol that the participants in the YES program would be referred by a
judge? It's by the judge would say, I think this should go to the YES programs, calls Department 2 and gets a date. The other glitch for many of you is you have to be in person. It's not feasible to do that remotely. That would not be feasible. If you are adamant that you're not coming to court or your clients aren't coming to court, then it's just a regular plain vanilla settlement conference.
And for the mandatory settlement conference that you referenced earlier, are those being strategically timed by the court a certain number of days or months before trial, or it's discretionary?
No, neither. It's really availability. To be honest, I mean, the home court believes the case should have a settlement conference. I've told the bench officers, if you're setting a trial, then it's always a mandatory settlement conference. If you've given a trial date, the conference you're giving is a mandatory. If you haven't set a trial, if you want to call it just a plain vanilla settlement conference, you can. But I really don't see the distinction. The local rule 5.14 still applies. You have to come in there serious. So to me, there's no distinction. I just know for lawyers, the word mandatory settlement conference has a different meaning to them. So if there's a trial, it should only be called that. But we can't strategically time it. When somebody calls, they get Fernando or whoever the clerk is, and they'll say the next available day is April 15th. My stomach drops. And, sometimes when people are in front of me, I'll try to figure out a way I can squeeze it in. I wish I could, have, like I said, everybody sitting down and talking to a judge before trial all the time, every case. And we just can't. We just don't. I mean, they do, but not in the mode of settlement.
Okay, with we only have a short amount of time left, and it wouldn't be an episode of direct examination if we didn't get a little bit into your personal history. So
okay.
we'll do the abbreviated version.
Okay.
When did you first start thinking about a legal career, and how did you eventually end up in law school?
Okay. No lawyers in my family. As far as I'm concerned, I had no thoughts about being a lawyer, although in reflection, I did my 8th grade career paper on being a lawyer. So I guess it was there, buried for a long time, went on, did a lot of literature, studied French, lived in France for a while, studied English literature, French literature. And lo and behold, like, now what am I going to do with my life? I always say my father was the biggest woman's libera I knew. And my sister is 15 years older than I am, said, you were raised by a different father, even though it was the same father. He wanted me to be independent and to be able to take care of myself, and said, now what are you going to do? You need a career. And I did not have this aspiration that I knew about being a lawyer. And it was sort of a friend of mine who said, I think you should take the LSAT. It was very different then, where it was not, I don't know anybody who took an LSAT prep class. And I heard about the Southwestern program, which was the 2-year conceptual approach. It wasn't that I was in a rush. I was interested in the conceptual approach to legal education. I went to Pitzer College, and it was a very innovative college. And it sounded, wow, this sounds really intriguing to me. And that's what I did. I applied and went. And it's a very rigorous program. So for 2 years, I didn't have time to think about if I liked this idea of being a lawyer or not, because it was so busy. So on one hand, I think I fell into it, but knowing that I wrote my 8th grade career paper on it, maybe I knew that's what I wanted to do. So I don't know. And I did watch a lot of Perry Mason. So, but I originally thought I would be a criminal defense lawyer, and that might have been Perry Mason stuff. But when I was worried about people's freedoms being in my hand, that was very scary to me. And I sort of drifted toward the civil arena.
How would you describe your law school experience?
Intense. Did not come up for errors. It's 2 years around with very little breaks, the scale program. So it was like one day I was like, oh, I'm studying for the bar.
And after you passed the bar, what was your first job as a lawyer? And I know you said you worked in civil, but what were you doing?
I worked for a lawyer in Santa Monica who had primarily business litigation and business transaction practice, and just did a variety of stuff for him. And in fact, working for him, I did a couple more than one family law case, but I did do a family law case for him for one of his clients. And I think it was a restraining order. This goes back a lot of years, and I didn't know what I was doing. And it's actually kind of a funny story thinking about that I'm in family law. And we were in court all day. That's what I remember. It might not have been all day, maybe it was all morning, but it seems like we were there forever. And I heard the judge, I think we were in San Bernardino County. We were sitting there listening to orders for custody, such as, okay, you drive up in front of the house, you honk 3 times, and then the kids come out. This is before texting. And I saw my client look at the other, party, and I could see they were aghast, that somebody was going to micromanage their life like that. And I looked at the lawyer, said, do you want to talk in the hall? Because I saw the look, and we settled the case. And that was my introduction to family law. I mean, they didn't get back together. They just settled the whole custody situation.
Oh.
We're not gonna, we're gonna handle this.
And from your civil assignment, your first civil job in the civil arena, how would you describe your path to the bench from there?
Every job I took, I think, was a path to the bench, to be honest with you, just not knowing it. And we don't have enough time for me to go through the different paths, but young in my career, I started doing hearings as a hearing officer for the Los Angeles County Civil Service Commission. And then I grew that practice and realized I really liked being a neutral, but I really liked also litigating. And it's a pretty long story. I first looked at being a magistrate judge for the federal bench, but I realized what I really like is working with people. And a magistrate judge for the federal bench, you're going to stay in chambers, you're going to do a lot of reading and writing and rarely see the public. And being with the public is what I like.
And for the last few minutes of the program, can you describe what you would like your legacy to be in the family law community?
I think the simple but big words, which aren't necessarily tangible, is to really know that the community knows that I care about the community, that I have since the day I started, and hopefully until the day I finish. I can't imagine that changing. That I've really, tried my best and hardest to benefit the public we serve. And I know some of that sounds like very miscongeniality, but I mean it sincerely. I think the court system is very hard for people, and especially in this division, because they're involved. And it's such an intimate part about their life. So I hope my legacy in that spiritual sense is that she really, devoted herself to the community and to the public. On a more tangible, I'm hoping to bring even more courts to our division, and to helping cases that don't need to be, bogged down in a system, get through it faster. Some cases, we all know, just are going to be litigated. They're going to take their life. They're going to go to trial. There's going to be a decision. There's probably going to be post-judgment litigation. But there's many cases that I think get kind of stuck. And I'd like to get the cases that didn't need to get stuck, just to get in and get out and be done.
What advice would you have for young family law attorneys just getting to work?
Be prepared. I'd say that for any attorney, but the big difference, I think, for family law practitioners from civil, criminal people are going to court. Civil practitioners don't go to court as often. So what we do in this division is you go to court. There's a lot of things that happen before you actually have your trial. It has to happen. So they need to be prepared. If you're young, and let's not even say young, let's not put an age. If you are a new lawyer, because there's new lawyers who are on their second and third careers, showing up in court and saying, well, it's not really my case, or I just got on the case, I don't care. I mean, it's, you should come to court and know your stuff. You should talk to your client. I mean, there's exceptions to that. Your boss or your partner called and said, I'm sick, I can't come. You've got to go do this. But then you should get as much information as you can. And you don't have to pretend you know something you don't know, but you should know something. You should get as much facts, call anybody else in the office and say, well, what do you know about this case? What can I get? Even call the support staff and say, give me the lowdown. Ask for second call, take 5 minutes with the client, said, I'm really sorry, Ms. Youngman couldn't be here today. She had an emergency. But this is what she told me, be prepared. Be prepared. And speak up. A lot of new lawyers are timid now, and when they're timid, just speak up.
Get close to the microphone.
Get close to the microphone.
Literally.
Well, this is, I think, perfect timing to wrap it up, so everyone can get back to their desks on time today. Thank you so much for being so open and sharing with us and participating today.
And happy 10-year anniversary.
Thank you.
Happy anniversary. For everyone still connected, don't forget to please mark your calendars and join us for our next episodes. First Wednesday of the month. Next up, like we said before, Michael Trope on February 7th, Kimia Klein, Adam Lipsick, and Evan Itzkowitz to follow. Thank you to Genna, Rin, Jose and Belinda at the bar, Family Law Executive Committee, currently led by Ava Jahanvash and Ashley Kwan. Thank you to our section sponsor. Thank you to Jenna Spatz for filling in today. And of course, again, thank you, Judge Kaufman, for being here.
Thank you, everyone.